5 seconds to go. Start. It is noticed that with such sweeping observation made by the learned single judge, the accused in FIR number 406 of 2020 have been ordered to be enlarged on bail, though the charges thereunder are grave, which includes section 302 IPC and section 27 and 30 of the Arms Act. The allegation is of indiscriminate firing, which has also resulted in the death of Ram Prasad Pandey, the brother of the complainant. It is no doubt true that the investigation has been carried out in the said case and the charge sheet is stated to have been filed. Further, the fact that the said accused persons had spent 10, 7 and 4 months respectively in custody seems to have weighed with the court, which could not have been a mitigating factor when charges of such serious nature are to be tried. The details furnished by the learned senior counsel for the state would indicate that 7 other cases are registered against one of the accused named Rajkumar Maurya, who is also alleged to be a part of the group of the accused in the instant case. In such circumstance, when the said persons are also stated to have been attacked by the rival group as alleged in the counter complaint of Sarvesh Tiwari in FIR number 407 of 2020 and the investigation is not yet complete in the said proceedings, it would not be appropriate for the said persons who were part of one group which had clashed against the other to be in a position to alter the nature of consideration when ultimately a composite investigation to complete the process in FIR number 407 of 2020 would also be necessary. Therefore, at the outset, when it is noted that Ram Prasad Pandey died due to firearm wood suffered by him, and both the FIR number 406 of 2020 and FIR number 407 of 2020 referred to the indiscriminate use of firearm in the clash, the release of the accused in FIR number 406 of 2020 at this juncture was not justified, more particularly in a circumstance where the learned single judge has not recorded his satisfaction with regard to the specific details of the case and the reason for which each of the accused was entitled to be enlarged on bail. At this stage, in any event, the role of each member in either group is not clear. Similarly, the complaint lodged in FIR number 407 of 2020 discloses that the allegation made against the appellants in the second set of appeal is also of grave nature, to the effect that the accused persons were armed with illegal weapons and due to the previous enmity they had come there with intention to kill the complainant and his associates. In that regard, it is alleged that the accused had indulged indiscriminate firing on the complainant his cousin brother, and that they fell down on sustaining gunshot injury. As against the said allegations, Mr. Siddharth Luthra, learned senior counsel for the said appellants, while seeking to justify the prayer for grant of anticipatory bail, has made strenuous attempt to contend that the said complaint is belated and lodged as a counterblast, though there is no truth in the allegations. In that regard, in order to contend that Anand Tiwari had not suffered gunshot injury, has referred to the medical certificate, which the opinion expressed is that the injuries which were shown to be lacerated wound are simple in nature, caused due to hard and blunt object. Though such contention is put forth, we are unable to appreciate the same in favor of the said appellants to consider grant of anticipatory bail for more than one reason. Firstly, the delay as alleged in filing the complaint would not be material at this stage when the ultimate reference is to the very same incident dated 8th May 2020. The allegation in the complaint dated 12th May 2020 is not relating to any other subsequent incident so as to deem it as a complaint filed as being in the nature of counterblast. Further, the very complaint registered at the behest of Lakshman Prasad Pandey in FIR number 406 of 2020 would indicate that in his complaint he has inter alia stated. Stop.